Yeah, so hi everyone. Welcome to this panel on legal and ethical aspects of generative AI and their impact on digital humanities. Thanks to Victoria for introducing us. Thanks for all of you to make an early day and join us for the discussion and for listening to what could be said about this topic. To give you a little bit of context, this crew kind of got together for the first time in Utrecht already for the DH Conference 2019, dealing with various copyright legislations in various countries, trying to get together people to exchange how legal regulations in their respective spheres of work and interest have parallels or have differences, and if we can come up with common denominators, or at least know about the troubles and worries that other colleagues have in different parts of the world. And ever since, we've been in touch. We've tried the odd little format with other conferences as well. And obviously, with the advent of AI last year, it kind of seemed ominous and logical to tackle that as our next playground to get the crew together and exchange how in our various spheres that we are working in, AI regulations are happening and how they are probably going to impact research and education and digital humanities in specific. So I think that's kind of the layout of the whole thing. We will have 4 presentations for you where we will present some stuff about AI regulation in our respective fields. And then we would actually switch not to a panelist discussion, but right into a Q&A, because I think it's probably more engaging and more fun if we just get into discussing things right away, and if you can get your opinions out and your questions out. And also, of course, since we can't cover the whole world, if you know about not copyright, obviously, but AI legislation in your various countries that we are not aware of, please share it with us, right? So we want to learn from you just as much as you hopefully want to learn from us. So let's learn together, and let's get started with Kim, who will start with the Canadian and US perspective.
Thank you very much. Can you hear me here? I know I don't speak very loudly. So just raise your hand at me if I'm not, if I start to trail off. So I think I have made a mistake already. Where did I put the slide deck?
You are screen sharing, but there is no screen.
There we go. Okay. Okay, here we go. So I'll just briefly explain. So I am the director of the law library at Cornell Law School, and I also teach a class, a writing course in comparative copyright law. So every year there's been some student or another who wants to write about copyright and AI. And of course, this last year when all the exciting developments were happening, I had the semester off from teaching, so we did not get to have that fun, but it did give me a chance to catch up on a lot of things. And I'm also actually Canadian, so I have a background, a legal career in Canada. I did a fair amount of copyright consultation and a little bit of litigation as well. So that's why I come to these 2 jurisdictions. So just briefly, I'm going to talk about 3. If you've seen the abstract, you'll see the 3 kind of themes that I'm bringing up. On where I'm thinking about issues heading when it comes to AI and digital scholarship activity or digital research, academic research of any kind. And I'll give you a brief legislative update on what's happening with AI in Canada and also in the US. And then I just have a last slide that has some readings elaborating on some of the points that I'm making. So, as you know, the research activities that you undertake when you're using generative AI, that can be outputs of AI processes, and that obviously has some potential legal implications. So we know that sometimes copyright protected works may form part of the training data for models. And we can think of, a model that you might not have created yourself, but you use, and it has acquired training data in it that might be copyright protected. And in such an instance, I think it's safe to say that in both Canada and the US, you as the individual researcher wouldn't be as much as the ingester of the work. You wouldn't be at, the fingers wouldn't be pointing at you so much as they would be with the creator of the model. And in the US, there are quite a few cases on this already. As you probably heard, that's a federal district, not an federal district court, dismissed state law claims. And this was an interesting one. It was this was by, you might have heard about several authors that sued OpenAI because it ingested their books in its model training. And so in this case, nothing happened yet, nothing was decided. The only thing that was decided was that the sort of state law claims in legal, like jurisdiction, like theft and trespass and those kinds of things, unfair competition, those weren't allowed to proceed because the court said this is really a copyright case and that one is allowed to go ahead. So we'll see what happens in that. And there are similar cases relating to music. And then you also might have heard about the New York Times case too, where they initiated proceedings against OpenAI. And that one is a little bit different because what they found in their evidence was actual snippets that were identifiable, extracts like plagiarism from New York Times articles. So it's a little bit closer to a true copyright infringement case than a case where you're just talking about improper, allegedly improper use of your copyright protected information. So your research can also generate texts and images or other data, and without your knowledge or express consent, that output that you generate can contribute to enhancement of models. And when we are all talking about academic researchers sharing with each other, I think most of us weren't concerned, and I think I heard somebody in another program the other day saying, you're welcome to have anything of mine. And, I regularly put Creative Commons licenses on anything that I make. But now we're in a different kind of environment where it's commercial. And sometimes you actually do give consent because you click on the terms of use agreement. Sometimes you click on it because you have to and you have no choice, and that might make you upset, but you need to use the tool, so you do it anyway. And sometimes you realize later on that what you agreed to ended up giving the commercial entity more value than you originally thought. And so these are other kinds of issues that there really aren't remedies for at this point. In my view, they're novel, they're different from traditional intellectual property cases. And when we come to the click wrap cases or agreeing to terms of use, those are contracts. So when you click a terms of use, you accept the terms, you've entered into a contract. And so generally speaking, that doesn't engage copyright law. Now you're into the license world, which is contract law. But just very recently, a case was the state elements, so the non-copyright elements of a case, a suit by the company formerly known as Twitter against a data scraping company. Those claims were dismissed and the copyright ones are allowed to proceed. And the reason was, and this is actually quite interesting, and it's a novel development in US law. We'll see where it goes because this was just the initial early stage level pre-trial. But what the court says was that the terms of use issues, they're really the same as copyright issues. And in US law, copyright law is a federal matter and it has to come first. So it is, we use the term preempt. So it preempts any state issues like theft or any other kind of, they had made a number of old law assertions in that case. And so it's allowed to proceed. This was just in May, so we'll see what happens next. But I thought that was a very interesting one, and possibly even promising for those of us who don't like clicker-up agreements. And then there's a more sort of nebulous way of conceiving what you're contributing and potentially exposing to AI. And this is your body of knowledge productive activities. The work that you've done, they can become inputs in somebody else's creation and use of AI tools. And this is the kind of thing that these other people are making suits about, but they're sort of only talking about their specific books or their newspaper content. When you think about the fact that you, throughout the course of your academic careers, are generating an immense body of creative, original knowledge, and that knowledge is now, if you think of that traditional sort of data, information, knowledge, wisdom hierarchy, you're at the top levels there now. But with the way things have gone in the last 20 years or so, knowledge is now becoming datafied. And with that exposed knowledge and vast amounts of it, you get something entirely different. And again, when it was in sort of an academic world, we might not have minded as much, or when we're controlling those large data sets and are able to generate patterns and discover new relationships, that was interesting. But when we are instead feeding a profit generating model, I think I have some more difficulty with that. So this is a different issue. We're seeing some people write about this issue. I haven't seen any litigation or any case law about it yet. But so again, we used to say, go ahead, use it, I'm honored. But now we're seeing different kinds of characterizations, the word appropriation, knowledge exploitation, digital capitalism, these kinds of things. And this is really, as I said, it's not really it's different from intellectual property infringement. It's different from copyright infringement. So sometimes you're hearing things like the words conversion, or which is like a form of theft. So, I think there are some legal scholars who are trying to work out what other kinds of wrongs, if it feels wrong, it might be wrong. And so in what legal form does that wrong take, is what a number of people are looking at right now. So, we had the Google Books case, the HathiTrust case, and those, making those corpora available for use and exploration were seen as wins, because that was for us. Now, I think that even courts, even in the US, are beginning to maybe see that differently. And I think if we're relying on cases like Google Books or HathiTrust, I'm not so sure the courts are going to continue to go in that direction, but we'll really have to see how things unfold. So in that era, and it wasn't that long ago, a decade ago, we weren't really conceiving of AI, generative AI, and massive profit generation. So, that's sort of where we are now. I have briefly some legal updates for you. There isn't any case law in Canada on this issue of copyright in AI generated works, which Paula will get into. But basically, most experts agree, no, it's not something that's imagined to have copyright subsist in it. And just very recently, a few weeks ago, there is a case that's filed in federal court where you might have heard about the Raghav AI generator and an image that was created, and this person went to different copyright offices around the world to try to register a copyright, and he did register a copyright in Canada. So now a public interest organization based at the University of Ottawa has launched a litigation seeking a declaration that copyright can't subsist in that image because it's not original and it's not the product of human authorship. And if copyright does subsist, it belongs just to the person who used the tool. The other update from Canada is there is legislation. It was introduced in 2023. It's currently called Bill C-27. It'll be known as the Artificial Intelligence and Data Act if it's passed. It's part of a very long bill that makes a few changes, but there's a good link here that you'll be able to get on the slides that gives a nice overview of what it does. And in the US, right now, what we have is an executive order from also 2023, and it sets out a framework that's based on these 8 sort of very executive order-like principles. And, you know, they're good ones. They're good ones. They're meant to protect individuals, but also meant to increase innovation. But in addition to that executive order, it's now led the way to 20 more bills in the US just in the last 2 months. So these are just some of the things that some of these bills will do. And there's a very good website at the Brennan Center, which I think is based at NYU, and they are tracking all of these different legislations that are in progress in the US. And this is a slide of readings that relates to the topic that I was talking about data appropriation. And now I will turn it over to Walter, and thank you for the extra time.
Yes. So hi, it's my pleasure to take you to Europe regarding the legislation on artificial intelligence. The situation seems to be a little bit easier, really, because we do have the AI Act, and we have to live with it whether we like it or not, because it will apply to all the countries in the European Union, and by default, it will apply to pretty much everyone else. Just as the GDPR, the General Data Protection Regulation, which hit us about 8 years ago, has also changed the way that we process personal data, but not only in Europe, but all over the world, because it has to be compatible and so on and so on. And I think that very same trend will follow up with the European AI Act. Just a very small context for me. My name is Walter Scholger, already mentioned at the University of Graz. I'm a historian by training. I dabbled in legal issues during my degree time, doing cultural management, whatever that exactly is supposed to be. So I ended up with an interest in legal issues of research and education early on, and someone at our institute had to do it, and that person happened to be me. So I've been doing that for the last, I don't know, 20 years, something like that. I'm in several European infrastructure groups dealing with legal and ethical issues of research and education, co-chairing ELDA, which is a DARIA EU working group with Koraljka. So yeah, I've been around in that area for a while. So just a quick check on terminology, really. Like, how many non-Europeans are in the room? Some. Okay, good. So just very briefly, basically to tell you how European legislation works, like on the European Union level. There are basically 2 different kinds of European Union legislations that we have, or legislation formats. One is a directive, and the other one is a regulation. Directive, the last one that kind of was particularly important for us as digital humanists, was the one on the digital, copyright in the digital single market, EU Directive of 2019. The difference between a directive and a regulation is that a directive is basically a set of agreed guidelines for legislation in the countries of the European Union and the European economic space, and then there has to be national legislation taking that up, right? So there is a guideline that you can basically, you don't have to implement all of it, and you have some leeway on the national level of how to implement it. So the directive is actually just that. It's a set of guidelines, and you have to implement it in national legislation. Whereas a regulation is European Union law as soon as it is passed. Usually that also means that there is national legislation following up on that, because each country will have their own kind of, interpretation of certain terms and stuff like that. But still, a regulation becomes effective European law for all member states of the European Union as soon as it is passed. So this regulation now that I'm talking about came to pass on the 13th of June. It was decided upon, laying down harmonized rules on artificial intelligence, in short, the Artificial Intelligence Act. It has finally been published. That's another oddity in the European system, because even if the European Parliament decided on the law, it's not valid until it gets published in the European Journal, which finally happened on the 12th of July. So it took some time to translate it in all the various different languages in the European Union. And it has been in effect since August the 1st, 2024, which means that the various regulations and measures included in this act will become valid law over the next 6 to 12 to 24 months, depending on what regulations we are talking about, right? So there's always a little bit of a period going there. Now, Europe was very vocal about being the first guys to have AI regulation on any larger scale, which was a blatant lie because China was quicker, a lot quicker actually, and my thanks go to Katie Du, who managed to basically have a look very briefly on the interim regulation of the management of generative artificial intelligence services, which was passed in China on August 15, 2023. So they definitely bet the Europeans to the punch. The interesting thing is that even down to, as far as I can tell, terminology level, I was using Google Translate, or Kelly helped with Google translating these things. It appears that the Europeans took some pointers, because there's really a lot of terminology that is very, very similar. Okay, so but what is actually in there? So the European Union Artificial Intelligence Act defines an AI system as AI system means a machine-based system that is designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that, for explicit or implicit objectives, infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. I think even that definition is something that we could probably quarrel about for 1.5 hours easily, you know. But essentially the gist of the entire regulation is one does not simply place an AI system on the market, because it's all about the market. And that's a very typical wording in European legislation. Unfortunately, it's all about the market. As I noticed before, like the regulation on the digital single market. That's where all, like for example, the text and data mining exceptions for research came from, which was a great thing, but it's all about the market, you know. So same thing, same justification here with the European legislation. And like the whole document is 144 pages long. So I will actually just really focus on what we promised originally, and that's research and education. So the good news is, or the really good news for us, I think, is that there is explicitly an exclusion of the regulation for AI systems developed solely for scientific research and development. So there is a statement to promote innovation, especially in a controlled university environment. And for anything that happens in such an environment, the regulation does not apply, which is very, very important. However, as soon as you take that system that you have been testing and developing and so on, and put it on the market, so publish it by any means, and market doesn't necessarily mean economic use, it just means putting it to the public, that exclusion ceases to exist. So as soon as you put your stuff out there, the system at least, the Union Artificial Intelligence Act fully applies. There are some limitations to this exclusion, or probably not limitations, but just extra points that people have to observe. So for example, any research and development activity should be carried out in accordance with recognized ethical and professional standards and in accordance with applicable union law. For example, the GDPR, when we are talking about the processing of the personal data, or the various text and data mining copyright exceptions. So all of these rights that are existing have to be observed, but then you still can work with a research setting fairly well, despite all of these things. I think that the major challenges will be the interpretation of what market means and what an enclosed system will mean. And that's, I think, going to be very interesting to look at over the next couple of months, how these interpretations will be handled by the big stakeholders of both the research and the political arena, more or less. But there will be this distinction between, like, where does the innovation system become a market system? Where is actually the fringe between research and education? If I'm using an AI and training an AI or training large language models in this scientific setting, and I can actually deal with the exclusion in that setting, as soon as I use it in teaching, it's not a research context anymore, but an education context, and any education context has different rules, and I'll get to that in a minute. So other things that are important about or research related about the AI Act is something that might be interesting for us as researchers. There is currently a lot of money going into common European data spaces. That's the next big thing. Like EOSC goes into that, the European Open Science Cloud, all sorts of different cloud structures that produce data. And these common European data spaces are supposed to provide trustful, accountable, and non-discriminatory access to high-quality data to train AI, right? So that's actually an interesting outlook that is in there as well. Something that is called for is AI literacy. AI literacy, not only for developers, but also for users of any AI system as an obligation, which has to be followed up within 6 months of the act coming into effect. So by next February, anyone who uses AI, whether it's in a company or at the university or whatever, will have to prove that they have taken steps to provide AI literacy to whoever is going to use their system. That's a pretty tall order, you know. And it's great for people like me who already know something about that. So, you know, I do workshops all the time these days. So, you know, that's really a tall order. And another thing that is very, very important and that will certainly change the game a lot because it applies to so many different areas, from proposal writing to assessment of papers, et cetera, is transparency, because there is an obligation for providers that they shall ensure that AI systems are recognizable. So the systems themselves, for example, if you come to a page and interact with a chatbot, it has to be obvious that that's an AI thing. It should be fairly obvious to begin with, but you know, there has to be a clear designation. And that the outputs of the AI systems are marked in a machine-readable format and detectable as artificially generated or manipulated. And that kind of just throws the entire discussion out of the window about like finding authorship and so on, because there will be an obligation to mark any AI-generated output. A very interesting piece that I just came across on the 4th of August, just while I was already here. OpenAI has a watermark system for their output ready. It's there, it's all developed. They decided not to roll it out because their user study kind of made them think that up to 30% of their user base would actually switch to a different product if they introduce watermarks, and therefore if their output actually becomes recognizable and identifiable. So, interesting market decision. However, we have a very, very similar situation as with the implementation of the GDPR. This will be applicable law within 12 months, so you will have to have that. And I don't think that OpenAI will just say, oh yeah, then we don't use the European market. I don't think that's going to happen. So they will have to implement it in some way or the other, right? So that's going to be a very, I think, interesting development. And it will also solve all these discussions that have currently been going on about, so, you know, there are so many research proposals that are now written with AI. or there are papers that are written with AI that we have to grade and so on. How do we find out that something is AI generated? That problem will actually solve itself within the next 12 months in the European sphere of influence, because there is a legal obligation to do that, right? So for education, very briefly, any education system is very much inside the AI Act, not like education, which has this exception, not like research, sorry, which has an exception, but also any education system is considered a high-risk AI system. So it has extra strong obligations attached to it, like risk management systems, technical documentation, record keeping, transparency, and, which is very intriguing, human oversight. So the ominous human in the loop that has been called for every once in a while regarding AI is also written into the Artificial Intelligence Act. The interesting thing to see here will be how they, closely define education or the use of AI in education. If I teach about AI, I'm using AI in education. What the article is more or less geared towards is actually using artificial intelligence to, sift through applications or for grading and stuff like that. That's considered a high-risk system. But of course, all sorts of other uses in the educational context might also fall into this provision, and that hasn't been really defined yet. And very briefly, I wanted to mention the Council of Europe, which is more like there is a difference between the Council of Europe and the European Union. It's two different bodies, basically, which are pretty much made up by the same members, but they have different scopes. So the Council of Europe is not a legal entity, or not, it is a legal entity, but it is not a legislative entity. But it does, for example, it passed the European Convention on Human Rights and stuff like that. So it is the kind of ethical authority of the European states. And they were actually much quicker than the legislation, so they already passed a framework on artificial intelligence and human rights. And I just wanted to share some of the wording that they used in their preamble, because I find it inspiring and very thoughtful and comforting that they were thinking that way. So on one hand, they see the big potential of this technology to promote human prosperity as well as individual and society well-being, sustainable development, gender equality, and the empowerment of all women and girls, for example. That's something that you will not find in the AI Act, but the Council of Europe makes that a very prominent position. However, they are worried about artificial intelligence systems' potential to undermine human dignity and stuff like that, or the risk of discrimination and all of that. So I think they have a very thoughtful approach to both the chances and the opportunities, but also the risks of AI. And they kind of have this beautiful sentence or beautiful term that I think is really central to whenever we have to talk about the use of AI in research and education, and that's responsible innovation. That's what it's all about. So thank you very much. I'm, of course, went over time yet again because I always get carried away. And I'm passing over to Pawel now. Thank you.
Thank you very much, Walter. Let me introduce myself. My name is Pawel Kamocki, and I am a legal expert at the Institute for the German Language. I am a trained IT lawyer, and I'm also a trained linguist, and I've been working on legal issues in language research for well over a decade now. I'm also chairing the Clarin Legal and Ethical Issues Committee that Walter humbly co-chairs. So we are colleagues, or at least partners, in the Clarin Legal and Ethical Issues Committee. Like all of us here, I have been intrigued by the developments of artificial intelligence tools, and I've been working on related questions for while now. I am also studying the AI Act very carefully, and hoping to contribute to the debate on the AI Act in the months to come. But today I brought to you a very small, sort of feasible, manageable issue to discuss in 10 minutes. That is the relation between the development of artificial intelligence and the presumption of authorship. So it has been brought to my attention many months ago that ChatGPT is listed as author or co-author of hundreds and now probably thousands of books available on Amazon. Now, and I believe this is just the tip of the iceberg, because I assume an even larger number of books are just secretly AI generated and just signed with a human name. And so a human represents the AI output as his or her own work. And yet, there seems to be a consensus that AI outputs in principle should not be protected by copyright. So there is a bit of a problem from the copyright standpoint, because we have AI generated text that represent commercial value, economic value, that are sold on Amazon, and that people pay for. They are not all of them, some of them, but by far not all of them are actually available for a price, not for free. The problem with this is that if you sign your name on a text, you benefit from the so-called presumption of authorship. And presenting a public domain item like AI generated text, something that should not be protected by copyright, something that should be in the public domain, is an act of copy fraud, but it's ethically wrong, it's morally wrong, but it's not punishable by law right now. So if you sign your name on AI generated text, you benefit from a presumption of authorship. And this presumption of authorship stems directly from the Berne Convention, which means that it's the same rule pretty much all over the world. It's also repeated in the EU Enforcement Directive, Copyright Enforcement Directive. And it's very simple. It basically says that the person whose name appear on the work in the usual manner, for example, Mr. Kevin Albert in the book, whose cover you can find on my slide. So if one's name is mentioned, it appears on the work in the usual manner, then this person is presumed to be the author and therefore have copyright in the book. Now, this presumption was introduced very, very long ago, and it made a lot of sense because, well, imagine many decades ago, it was actually very, very difficult to prove authorship of a book. So if a book was printed with a person's name on it and everybody seemed to be fine with it, nobody was protesting, then it was considered proof enough. But now at the time of artificial intelligence, I think this presumption generate some rather unwanted consequences. Because it can disturb the publishing market. What's the incentive of writing and publishing a human written book when we can just generate a book with an AI tool and benefit from exactly the same rights? We have the full copyright protection. Just to overturn this presumption, the only way would be to prove that the book is indeed AI generated, which is rather impossible in the current state of technology. I'm pretty sure that many of you know that OpenAI actually had a project on detecting AI-generated texts, but they abandoned the project because it was not yielding any satisfying results. So it is practically impossible to prove in court that a particular piece of text is AI-generated. So this presumption of authorship is indeed very, very strong. However, OpenAI also has terms of use. If you use ChatGPT, you accept OpenAI terms of use, and these terms of use actually prohibit users from representing output as human-generated. But the worst thing that I imagine can happen to someone who violates terms of use, OpenAI terms of use, is a suspension or, well, yeah, it's a suspension of an account. So it's not a dire consequence. So we are facing a big problem. AI-generated texts are virtually indistinguishable from human-generated text, and it is enough to sign. Currently, it is enough to sign AI-generated text to benefit from a presumption of authorship and practically benefit from copyright protection. This is indeed a problem, and a problem that is partly addressed in the AI Act that introduces a transparency obligation, as already mentioned by Walter, in this Article 50, according to which the providers of AI systems, so not the users, it's really the provider, it's OpenAI in the case of ChatGPT. Providers are obliged to they shall ensure that the outputs of their systems are marked in a machine-readable format and detectable as artificially generated, as far as technically feasible. So indeed, the future is watermarking, almost certainly. And this will properly address the problem, but then I believe that people will quickly find ways to work around those watermarks. For example, if an AI-generated text is just edited afterwards by a human being, carefully reread and slightly improved or slightly modified, will it destroy the watermark? Will it count still as AI generated? So will the presumption of authorship apply? Time shall tell. I have no answers. I only have questions. Yeah, this is a little problem that I wanted to make you aware of. And I'll be happy to discuss it with you during the discussion session. Thank you very much for your attention. Greetings from my family vacation. As you have noticed, I'm not joining you in person today, but I'm pretty sure that for the next DH, I'll do my best to see you. All right, thank you very much. And I will leave the floor to Koraljka.
So, hello. Before I start with my presentation, I need you to know that I'm a cultural anthropologist. I'm currently involved in the field of digital humanities, but I'm not the expert in law and ethics. But like all of you, I must consider these issues in my work. With so many ethical issues surrounding AI, it is impossible to cover all of them in just 10 minutes. So I'll zoom in on a few key topics that go beyond the legal realm and that I personally find particularly intriguing. Even though today's panel primarily focuses on legal aspects, we can't ignore, sorry, just miss my notes. We can't ignore the ethical questions that are deeply related with these discussions. As we have seen in all these previous presentations, ethics and laws are intertwined, and legal frameworks must evolve to ensure that AI practices align with core ethical principles. While discussing the ethics of AI, it is crucial to understand its fundamental nature. My computer science teacher often said in the late 1980s, when computers were just becoming part of our daily lives, and we were very impressed as a kids with their possibilities. A computer is stupid. It only knows and can do what it is programmed to do by a human. I often remember his words since this insight remains relevant today. And I would add, since we are talking here about computer ethics and AI ethics, that computers, just like AI, are amoral. AI itself cannot be moral or immoral because it lacks consciousness and ethical judgment. And it functions according to algorithms and programming created by humans. Its decisions and actions are based on the data and code, not moral considerations. However, the outcomes or behaviors produced by AI can be perceived as moral or immoral based on its design and application. That means that the responsibility for the ethical use of AI rests with the humans who develop and implement these technologies. When it comes to legislation, laws are here to ensure the safe and ethical use of this technology. However, I was wondering what the limitations of laws regulating artificial intelligence are in addressing ethical challenges. First of all, they often struggle to keep up with how quickly AI evolves. AI is complex, and lawmakers can find it hard to understand and regulate effectively. Existing laws on privacy and data protection don't always address the unique challenges of AI, like handling big data or dealing with bias. So to tackle these problems, we need continuous teamwork between lawmakers, tech experts, international organizations to create laws that are current, thorough, and ethical. To make laws truly effective, we need global ethical guidelines that can guide and shape them. And I'm sure that academic community is just well positioned to lead this effort. But why are these guidelines so crucial? Every country has its own set of laws, but beyond legal frameworks, the understanding of what is ethically and morally acceptable can also vary greatly. So we need to have in focus also the different cultural perspectives, and we need to strive for global ethical standards that encompasses diverse cultural values. AI brings up major ethical challenges like data privacy, security, bias, which cross national boundaries. AI technology knows no borders. Whether it's developed in one country or used in another, its impact is felt worldwide. To manage this, we need global ethical guidelines that ensure AI is developed and used consistently, no matter where it's deployed. Without global ethical guidelines, there is a real risk that different countries or companies will follow their own varying standards. And this could create a sort of ethical marketplace where some might choose weaker regulations to their advantage. There are, of course, some international global initiatives and guidelines published already. Walter mentioned some of them. There are UNESCO guidelines, these EU regulations. There are some national global initiatives related to AI ethics. They are not useless or bad, but they are quite general and don't address all the problems. Discussing the ethics, we need to have on our mind that at all time that AI can have worldwide implications, affecting various sectors, altering international relations, and so on. AI-generated content can be used to manipulate political processes and destabilize democratic institutions. You might recall media reports about the misuse of AI during the US presidential elections, for example, in 2016, but also in 2020, or you can see them these days in the contemporary elections. Additionally, we need to be aware that AI-generated content can shape public opinion in various ways. Deepfake technology, for instance, can create convincing fake videos of public figures, spreading misinformation or discrediting individuals. A notable example is a fake video of President Barack Obama from 2018, in which he appears to say things he never actually said, which went viral and highlighted the dangers of such technologies for the credibility of information and public perception. And also in yesterday's note, we heard about manipulation campaigns in Kenya, where AI generated false news articles which were used to mobilize people against the Western world, Western cultures. Also AI-generated content can have a significant impact on culture. For example, an AI artist known as Robbie Barrett, I don't know whether you, Kim, were talking about him or somebody else, uses deep learning algorithms to create abstract works that are displayed in prestigious galleries. The issue of authorship in the context of AI opens up a broad spectrum of ethical dilemmas, as previously discussed by Pawel Kamocki. We can also further discuss the nature of creativity, authenticity, the value of AI-created art. Can a work created by AI be valued and considered as authentic and as creative as one created by a human? It is important to be aware of these impacts of AI and to develop strategies for managing and regulating its use to minimize negative consequences. And next, I want to delve into the issue of biases. which is something that concerns me deeply. Bias in artificial intelligence algorithms refers to situations where AI algorithms make decisions that unfairly favor or discriminate against certain groups of people. This bias can arise from various sources, including biased training data, the design of the algorithms themselves, or decisions made by developers during the creation process. For example, face recognition algorithms have been shown to have higher error rates for individuals with darker skin compared to those with lighter skin, according to the studies by MIT and Stanford. And while these face recognition algorithms can be valuable in humanities, such as in archiving and analyzing historical photographs, the problem is that many of these algorithms are trained on limited and incomplete data sets. And if an algorithm is trained on biased data, it will produce inaccurate results, severely distorting research outcomes. This is a simple example of how using flawed or insufficient data can cause harm, lead to incorrect conclusions, or further already marginalized communities and societies. However, looking at the brighter side, AI and algorithms also have the potential to help reduce social inequalities. And here I see the main role of the DH community as guardians of interdisciplinary research that bridges technology with the humanities. Our community is uniquely positioned to advocate for ethical principles that prioritize human well-being, inclusivity, and cultural sensitivity, and promote social justice. By developing and implementing unbiased and inclusive AI systems, we can use this technology to identify and address disparities, improve access to resources, and support underrepresented communities. Here are some key ethical imperatives. While I may not cover every aspect due to time constraints, as mentioned earlier, this is a broad and complex topic, but I've already touched on some of these points, but there are, of course, much more to explore. Of everything, I would like to address only one thing. I think it is very important to focus on educating the broader community, especially the younger generations from an early age, so they grow up to be morally and ethically aware individuals. Digital humanities can develop educational programs that teach the public about the ethical implications of AI. By fostering critical thinking and ethical awareness, these initiatives help ensure the future generations are shaped and are equipped to engage with AI technologies responsibly. And to sum up, it is essential to have strong laws and regulations, of course, but it is just as important to work on increasing public awareness about the ethical issues about the use and development of AI. And furthermore, the establishment of global ethical guidelines is crucial to provide a consistent framework for AI development and use worldwide. And I think the ADHO community has a pivotal role in this effort. Thank you.